Okay, we're picking up where I left off. This is going to be Distance Learning 3B, since apparently my video cut out and I wasn't completely done. So we're going to continue along with that same topic. We're going to talk about pleas and plea bargaining. And so this will be a continuation of Distance Learning number 3. It'll be known as 3B for Western Michigan University Political Science 3250. Okay, as I mentioned, these are the various types of pleas. We should go over what they are so that you're all on the same page. The first of which is going to be known as not guilty. The second is mute. The third is guilty. The fourth is no contest, sometimes referred to as nolo contendere. The next one is guilty but mentally ill. And then finally, not guilty by reason of insanity. Again, not guilty, mute, guilty, no contest, guilty but mentally ill, and then finally not guilty by reason of insanity. And we'll talk about each of those individually. So starting with the first one, that being not guilty, what does that mean? Well, when an individual comes in, they're arraigned, the judge asks the individual how they wish to plead, and if they say not guilty, they're simply expressing to the court not that they did it, not that they didn't do it, but as of today, they wish to plead not guilty of the crime or crimes they've been charged with. If in fact not guilty is entered as the plea, then the next stage of the process will begin. That will include the setting of a bond, which again we'll talk about later, and moving it along the criminal justice process, keeping in mind an individual's Sixth Amendment rights. The next one on our list is mute. That is, if an individual chooses to stand mute. The standing of mute is the effect of pleading not guilty. Since the court can't force an individual to speak when told of the charges, if the person chooses not to speak, not to say anything, the court will enter that they are mute regarding the charges. Practically speaking, it has the same effect as if somebody had pled not guilty. That is, the court then would set a bond and then schedule the next appropriate hearing, whether it was a pretrial or whatever. So not guilty and mute have the same effect, but they're two different types of entries of pleas once somebody is charged with a crime. The third is if the person chooses to plead guilty. Now, at an arraignment, not many people actually plead guilty at the arraignment because it's the very first stage of the proceeding and the very first stage in which they have the right to have an attorney assist them. So more often than not, an individual won't plead guilty because they want to talk to a lawyer. They want to look at what the evidence is against them before they choose to enter into some type of plea where they admit their guilt. If someone chooses to plead guilty at that point, or if they down the way choose to change their plea, that is from not guilty or mute to one of guilty, then the court goes through a particular process. That is, when the judge decides that they're going to go ahead and accept somebody's guilty plea, what the court is required to do is to put the individual under oath, inform them that they have the right that is associated with the Sixth Amendment to have a lawyer. Again, these are subsequent rights that we're telling of them, that they have the right to have a lawyer, they have the right to have a trial. They understand if they plead guilty, they would be giving up these rights, and the court ultimately would receive evidence from an individual who would be testifying under oath that they committed a crime. Again, an accused is put under oath. The judge asks a series of questions of them to make sure that the plea is knowingly, voluntarily, and understandingly made, and that they admit to a criminal act or criminal acts. That's how the process of pleading guilty takes place. An individual may also plead what is known as no contest, which is the fourth one on our list. Again, also referred as the Latin term nolo contendere. What no contest means is that an individual isn't admitting guilt and they're not denying guilt. That is, they're not saying that they did something wrong, but they're not saying that they did not. It has the practical effect of, in a criminal court, of pleading guilty. But sometimes an individual will choose to plead no contest because they're concerned about a number of things. First, they can't plead guilty if they don't remember what happened. Maybe as a result of drugs or alcohol or some other situation, they don't recall what they did the day of the incident. If they can't remember, then they can't effectively plead guilty. So they may choose to plead no contest, meaning I'm not saying I did it because I don't remember, and I'm not saying that I didn't do it. In a case of no contest, if the decision is made because the person doesn't remember, doesn't recall because of whatever instance, the court would receive evidence from a police report, for example, that would demonstrate that the accused actually did commit the crime. So the person who's accused of the crime wouldn't be relaying the information under oath. The court would just receive it from another source and then ultimately treat the person as if they had pled guilty. So if you can't remember what happened because of substance use or whatever, you can't effectively plead guilty. Another reason why someone might choose to plead no contest is because they're concerned about civil liability. So for example, if someone's charged with an assault upon a person, if they came into criminal court, pled guilty to assault, then as we talked about when we talked about civil cases, the victim could then take that plea of guilty into a civil court, and they'd have a much easier time demonstrating that the person is responsible for the assault in civil court that might ultimately reward the victim money. If an individual does not want to expose themselves to the financial problems associated with civil court, but does not contest the criminal proceeding, then they may choose to plead no contest. In other words, no contest is an option to avoid the ramifications of civil liability. So if a person comes into court having been charged with an assaultive crime, they plead no contest, the court goes ahead and receives the information from another source, then the individual who's accused of the crime isn't in a worse position in civil court. The plaintiff still, in a civil proceeding, would have to prove that the person committed an assault using the procedure in civil court. So there are really two reasons why someone might plead no contest. They don't recall, or by pleading guilty, they expose themselves to civil liability. So those are the first four, and the more significant, meaning the more popular ones: not guilty, mute, guilty, and no contest. Then we move on to guilty but mentally ill and not guilty by reason of insanity. Guilty but mentally ill essentially means that the person is acknowledging by pleading guilty that they committed a crime, but because of their mental illness, they're asking that the court treat them, if you will, with kid gloves. That is, not as you would somebody who doesn't have a mental illness, so that the punishment and or the incarceration period and or the treatment may take into consideration their mental illness. So it is still a plea of guilty, acknowledging under oath that you committed a crime, but due to their mental illness, they should be treated with a bit more sensitivity than otherwise would be given. And then finally, there's not guilty by reason of insanity. In that particular situation, a person is saying, as we talked about when we talked about insanity, not that they had that they didn't have the mens rea to commit the crime, that they may have actually acted in a manner that looks like they committed a crime, but because they lack the mens rea, that is the intent associated with the crime, and they lack the intent because at the moment it occurred they were insane, then they would be regarded as not guilty by reason of insanity. Again, that doesn't mean that they didn't commit the act. It just means that because they didn't have the mens rea portion of a criminal of a crime, then they're not going to be treated as if they did commit the crime. So not guilty by reason of insanity is either a plea that is offered, or a jury could ultimately find somebody not guilty by reason of insanity. And if that's the situation, then the person is confined to a psychiatric hospital for a period of time. And ultimately, once the person is better, should they ever achieve, kind of a normal psychiatric condition, they would be released from the care of a psychiatric facility. If that's the case, they do not have a criminal record because ultimately they were found not guilty. That is, the mens rea was never able to be established by the government. If someone chooses to plead guilty or plead no contest, then they're waiving a number of rights along the way. The right to a trial, the Fifth Amendment rights to remain silent, They're waiving issues that relate to whether or not there was an illegal search and seizure. They waive their right to a speedy trial. All of these things are waived by virtue of their decision to go ahead and plead guilty. Again, if the individuals choose not to enter any of these pleas, if they continue to plead not guilty or continue to stand mute, then what happens is the case continues along the process, and ultimately a trial would be scheduled and held to determine whether or not somebody is guilty or not guilty, or guilty but mentally ill, or not guilty by reason of insanity. So these are the types of pleas that could be tendered. At least one of them has to be tendered at the arraignment stage. And of course, over time, they may change if an individual chooses to change what their plea is. If they plead guilty at their arraignment and they're ultimately sentenced, then, of course, you can't change your plea because the matter has been resolved. I want to spend a minute talking about plea bargaining. That is this concept where the government engages with an accused an opportunity to resolve a case. There is no constitutional right to have the government engage with an individual in plea bargaining or entering into a plea agreement. The decision to do so is vested entirely with the executive branch of government. Only the prosecutor can authorize a reduced charge. If there's probable cause to believe that you committed a particular crime, then you're going to be either held to answer that crime if you're found guilty or plead guilty. But at times, the government may choose to enter into an agreement with you to resolve the case short of going to trial. There are many reasons why the government may choose to go ahead and enter into a plea negotiation to get a plea bargain. And we should talk about why those exist. So a couple of them are the accused themselves may be a pretty good person. Maybe they're a young person who made a mistake. They've been charged now with a felony, and the prosecutor finds it's in everybody's best interest that they not be saddled with a felony conviction on their record. So the prosecutor may engage in plea bargaining with the accused if, in fact, that defendant is a good person otherwise. Sometimes a defendant is needed to testify against a co-defendant, and in order to go ahead and do that, the prosecutor may engage in plea bargaining with the one defendant to give them a sweeter deal, if you will, in order to get them to testify against a co-defendant. Occasionally, there's the desire of the victim. Maybe somebody is charged with a sexual assault case, and the government has evidence, obviously, that the person committed a sexual assault, but maybe the victim isn't the best of victims to testify in court. So in order to have the victim be relieved from the obligation to come into court and testify at a trial, maybe the prosecutor will choose at the victim's request to offer something that's less painful. So the desires of the victim may come into play. Sometimes you deal with issues of overcrowding. If there's overcrowding in the prison or jail system, there isn't a whole lot of incentive not to plea bargain, because maybe what you would like to get as a prosecutor isn't going to happen because of an overcrowded situation. So you offer something to the accused in order to resolve the dispute, resolve the case, because of the pressures from outside agencies like the prison system. In Kalamazoo County, there are 1,800 or so felonies charged every year. There's only a certain number of judges, only a certain number of courtrooms. If every single one of those went to trial, the system would be overburdened. And so because of that, time and effort put into prosecuting only those cases that are actually necessary to prosecute are the ones that the prosecutor focuses on. All the other cases, it looks like that they would maybe have good evidence, but there's no room because of time and money and limitations. They will engage in some plea bargaining with the defendant. But again, a defendant doesn't have a constitutional right to force a prosecutor to plea bargain. If the prosecutor wants to charge somebody with multiple crimes and they're not going to offer anything, there's no incentive for an individual not to take it to trial. So with all of these pressures that exist through the system and individual interest on a particular case, more often than not, cases get resolved through a level of plea bargaining. There are two different types of plea bargaining, broadly speaking. There's what's known as charge bargaining and sentence bargaining. Charge bargaining is that the prosecutor bargains with the individual on the charge that they're going to get. So, for example, if somebody's charged with a felony offense of resisting a police officer, the prosecutor may say to the defendant, listen, I will offer you a lesser charge, maybe an attempted resisting of a police officer, which is less painful. It's a misdemeanor compared to the felony. You bargain away the charge. That's called charge bargaining. There's also what's known as sentence bargaining. That is, the prosecutor sticks to the charges, but then tells the judge the person should receive a lighter sentence. That's what we commonly refer to as sentence bargaining. So, for example, in a community where maybe the prosecutor wants everybody who was out drunk driving to be held accountable for drunk driving, that is, they charge everybody with drunk driving and they want convictions for drunk driving, but they'll work on the sentencing end. They'll tell the judge, even though he's been convicted of drunk driving or pleads guilty to drunk driving, we want a lesser sentence. That's called a sentence bargaining atmosphere. Prosecutor can take the position of charge bargaining or sentence bargaining on the cases that it feels it's appropriate, but those are the two broad ways in which the prosecutor generally tries to engage with the defendant and bargain away the cases. Because again, there are far too many cases in every jurisdiction that everyone charged with the crime would have room to have their trial if they wanted it. That's why the bargaining process begins. So I'm going to wrap that up right now. That'll be the end of the March 16th grand jury's arraignment, pleas, and plea bargaining process. The distance learning number 3 was broken down into two categories. That is the first one, which was certainly just grand juries and arraignments. The second one, which I call 3B, that is pleas and plea bargaining.